sir. We can, sir.
All right.
Welcome. Welcome.
Please
Thank you so much.
carry on.
Yeah.
Please start.
I welcome all the participants. Well, good morning, all of you. Insolvency and Bankruptcy Code is considered as the biggest economic reforms in Indian history, at par with GST naturally. The step of Indian government is always proved to be a game changer and instrumental in unlocking the stuck capital into the economy. The prime objective of the Code 2016 is to consolidate and amend the laws relating to deorganized and insolvency resolution of corporate persons, partnership firms, and individual in time-bound manner. Further, the code emphasized to realize maximum values of assets of such person and promote entrepreneurship. The forward move of state proved as an instrument in bringing in timely, swift, and quick time-bound intervention, be it by way of restructuring, which in a vegetative state for a long time. This webinar, under the theme Insolvency and Bankruptcy Code, Ushering our New Era, will concentrate or bring into the light emerging and contemporary issues under insolvency and bankruptcy, and will focus on creating a national-wide conversation, providing an opportunity to students, academicians, law professionals, and all others stakeholders to be exposed to professional expertise of our esteemed speaker, Mr. Vishwajit Das, on insolvency and bankruptcy code. Mr. Vishwajit Das is a practicing advocate and managing partner of Juris and Juris, a law firm having its practice territory spanned throughout India. He specialized in the following areas with application of constitutional principles and rule of law. The list is long: corporate law, direct, indirect taxes, finance laws, including securities, banking, insolvencies laws, mining laws, corruption, black money laws, real estate laws, IPR, food and health, environment, and forest law. His forte is the simplicity with which he brings confluence among constitutional doctrines, rule of law, basic and established jurisprudence by engaging the scientific concept in law to secure the outcome in a predictable way. He strongly believed that law is simple, arithmetic, and its outcome has to be predictable and uniform. He borrows his skill involving scientific temper from his professional education. His background is science. He has done LLB, CS. He has degree of CA, CFA, etc. And he actually uses the same to its good effect in practice of law. He has been practicing for last 16 years in almost all fora, including Supreme Court of India, about 14 high courts, and many other specialized tribunals and quasi-judicial tribunals. He could secure the unprecedented success result in litigation due to designing and applying a completely fresh and different structure of jurisprudence, not practiced as yet by anyone. He believes the current form of jurisprudence has outlived its space, and time, thus newer jurisprudence backed with scientific temper, is the way forward to secure our civility. He has designed many unique ecosystems to augment and accelerate the growth of entrepreneur environment in India, and is actively involved in advising government, universities, industries, and institutions like ICSI, ICAI, IICA, etc. Most notable, he is part of advisory committee of GST Council since the making of its legislative design, and continues to facilitate its smooth implementation and enforcement. He is also the pivotal advisor to highly reputed techno-legal organization called MS Center for Health, Environment, and Food Safety, which is engaged in providing the policy advisory, advocacy, critical public-centric litigation, etc. activities. We are privileged to have you, sir, with us. I welcome you, sir, to enlighten us with your expertise on this turmoil legislation which brings renaissance in social and economic law. I'd like you all to welcome him with a great applause.
Thank you.
Welcome, sir. We are there to listen to you, and this is our privilege to have you here.
Thank you, Nidhi.
Thank you very
I
much, sir.
think, yeah. So now you are giving the feed to me to take over from you.
Yeah.
And Major General Mr. Sharma, thank you so much. And Ms. Nidhi, that is a very elaborate introduction about me. I'm humbled by your kind gesture. And I also am extremely thankful to Major General Sharma ji, as well as the Amity University Management for giving me this opportunity to give this perspective of IBC before your August audience. But I consider this as a responsibility that when 1.5 hours is given to me for each person, but with the number of people multiplied, that is a responsibility I have to carry on my soldier for the next another 1.5 hours. Sorry for the delay, as we know that the technology perhaps is the way forward, and the courts have started embracing this video conferencing. And when we appear in the court also these days, these small nagging points are always there. Now, to begin with, COVID has given this opportunity to use the technology. And we have no other option to embrace it. Now let's talk about the IBC. The era. Let's begin with the era. Ushering in the new era. What is this era all about? And while I begin on this topic, I think your audience would have heard many other speakers ad nauseum on this subject of law, because one of the most important mainstay of the current legislation. This era is a subject which actually important for all the stakeholders. Now, before me, there are 4 or 5 class of stakeholders who are there, and I have to address their expectations. One, the student class, where they will become professionals like us, either joining corporates or joining profession. Second is the faculty members, the erudite faculty member of the Amity University. Third, the management, investor, promoter, ordinary citizens. And then, of course, my colleagues, professionals. So there are 4 broad classes of the audience today is there. I would like to take forward this exercise more of an interactive rather than a one way of interaction, because that is where perhaps will give me an idea as to how we will be able to understand different criticality of this particular legislation. Now, therefore, I would like to tell you that in the context of the IBC 2016, I wanted to divide it into 2 categories. One, that is what is the bird's eye view of the IBC 2016. And second is the IBC vis-a-vis other statutes, right? So there are broadly, while we are discussing about this ushering in an era, IBC 2016, I'm broadly dividing it into 2 categories. The first category is the bird's eye view, a bird's eye view of the IBC 2016. And second broad category is IBC vis-a-vis other statutes. Now, the first category, I would like to frame off everything within 30 minutes, preferably, so that I will be able to take critical questions, because I'm not a teacher. I'm more of a professional. And when Major General Mr. Sharma ji told me that faculty and professionals, particularly the students, they look forward to a era of teaching or era of enlightenment where they can understand what is the theoretical part and what is the practical part, and what So what I would like to show more of a practical aspect. So 30 minutes I am confining myself for the purpose of giving a broad bird's eye view and a comparative analysis between IBC 2016 and the other law. Now the first category, the bird's eye view, I have divided it into 5 categories. Number 1, that is your the historical background and trigger for the IBC 2016. That's 1. This is a sub-pointer. Sub-point 2 is actually the legislative objective, the IBC objective and statements of objects and reasons. You have touched upon this issue broadly, and therefore will not go. But then, as far as my classification for the purpose of this particular webinar, this is a second sub-pointer under the category of the broad bird's eye view. Now, the third sub-point is the design, the structural design of the IBC 2016, which is a more of academic. And the fourth category is the legislative change from 2016 May of enactment of enforcement of IBC 2016 till today. So what is that legislative change that traversed throughout last 4.5 years, about 4 years? Now then, fifth sub-point is the judicial routes that we have traversed all through for last 4 years. This is under the first category, and second category, as I told you, that a comparative analysis, which perhaps will be more beneficial to the students and perhaps for the other participants to know. Now let us talk about the first sub-point of the broad category, that is called the legislative history and the trigger. If you remember, the IBC, the Insolvency and Bankruptcy Code, is a kind of a code, is a third code. I always call it as a third code. CPC is Civil Procedure Code, then Criminal Procedure Code, and now the Insolvency and Banking Code in the financial sector. And there is also a fourth code, but it has not been notified by the President. That is called the Wage Code. So broadly, this is a code of that kind where it talks about more of a procedural law. But we'll, as and when we will discuss about it, we will understand that this is no more confined to the procedural law. This also touches upon the rights and liabilities. So substantive law. Now, the background is we had the earlier laws then. For example, the 1909 and 1920, there are 2 enactments, pre-independence enactments on the insolvency law. Presidency Town, the Insolvency Act of 1909, and then the Act of 2020, that is Provincial Insolvency Act. Though we never applied it, but it was there in the statute book. These are the 2 statutes, these are the insolvency laws were there in that nomenclature. However, for the purpose of understanding these particular other branches of law, which we will discuss at the second broad category, that is vis-a-vis other statutes, there are also other laws like RDD-BFI Act of 1993 and SURFICE Act. There are also banking and financial related laws, and till today they do exist. In the background of this, when the legislature found that these 2 legislations, 93 and 2002 of SURFICE Act, were not effective and is leading to delay, they brought about this IBC, and triggered by the fact that we were having, by the end of December 2015, we were having a mounting NPAs to the tune of about 10-11 lakh crore. To deal with the liquidity issue and unlocking the locked money, the legislature brought in this IBC 2016 with a completely new design and new idea, like information utility as a concept, in addition to the earlier insolvency laws. So the trigger was obviously the NPA, mounting NPA, which is to the tune of 11 or 12 lakh crore was NPA. So that triggered. And the IBC 2016 came the month of May 2016. And let me tell you, when the legislative background to the IBC and the trigger, it is very important to note what is the objective within which this particular act came into being. The objective, as you have lucidly pointed out, this is as a subpoint, second subpoint. The objective was obviously to hasten the process of recovery, not necessarily a recovery, but an insolvency proceeding and a bankruptcy proceeding. What is this insolvency and bankruptcy proceeding? There was a two other law, 1909, 1920. They were repealed and a new law was brought in. That is 2016 IBC code. It is actually a composition of about 11 laws regarding the insolvency context, and they are part of the schedules of the IBC 2016. And objective was to augment the entrepreneurship. Objective was to fasten the process of resolution process and reorganization of the corporate entities, individuals, partnerships, firm. So broadly, all kinds of entities are covered under the insolvency and bankruptcy. And insolvency is a component which is actually confined to a reorganization exercise, where a person is saying, I'm insolvent, my liquidity is hit, and please work out for an arrangement to that effect. And bankruptcy is something the owner of the entity or manager of the entity is saying that, look here, I'm done, my hands are tied, I am no more in a position to run the business, and therefore declare me as a bankrupt. And in that event, when it comes to bankruptcy qua a company, it is called liquidation. When it comes to individual and partnership firm, we call it as a bankruptcy. And there are two kinds of forums identified for dealing with the insolvency and bankruptcy qua your liquidation qua corporate persons. And the second category is the insolvency and resolution qua the partnership firm and the individuals. So this is a design. And NCLT and NCLAT are regarded as the forum. That's part of the IBC code, that they are given the adjudicating authority of dealing with insolvency and resolution. These are all broad areas of legislation design. And there is a DRT which is still functional under their old law, which was constituted under the IDDBFI Act of 1993, and also performed its function under the SARFAISI Act of 2002. They were empowered to handle your insolvency and bankruptcy of the partnership firm and individuals. So mind you, while the Insolvency Bankruptcy Code 2016 is in operation, the other two laws, they are broadly recovery laws. That is RDDBFI Act of 93, which is now being renamed as the Recovery of Debts and Bankruptcy Act of 1993 now, and which is amended in 2016 August. That law is still subsisting with its scope of operation, and the SARFAISI is still operation with respect to secure property, enforcement of secure property. So when we talk about the insolvency and bankruptcy law, understand there are three broad laws operating. While we talk about the objective which you have elaborated, don't need to go into that. That will eat away our time. Please understand, IBC as a legislation brought in to enforce reorganization, insolvency, and liquidation in a time-bound manner, so that to enhance, to achieve a higher degree of valuation, so that we don't have to wait for long. Because enforcing under the Act of 93 or 2002 was time-consuming. Obviously, you have to then quantify, you have to then enforce it, you have to execute it. So therefore, all the procedures of law will operate. Even those statutes were also operated under a time-bound manner, but that did not work out, because that's, of course, is a part of the recovery procedure. Now, here is also a case where it is more of not of a recovery procedure, but of an insolvency, where somebody is saying that, look, I'm insolvent, please, let's have a handshaking. And I always have argued that the insolvency is nothing but a rename of the one-time settlement scheme of the RBI guidelines under the RBI Act. Like a company is suppose owes a lakh of, say, for example, 2 crore rupees to a bank or financial institution, and he's not in a position to pay that principal amount, then it will give it a kind of a OTS scheme, saying that, look here, I have this kind of financial problem. Now I cannot repay your money because of the business risk and all. So the IBC is a sort of giving a structure, a statutory structure to the OTS scheme that is worked out under the RBI Act. And why we needed this kind of a statutory structure? Now, students must understand, when they are going to practice tomorrow, or they will join corporates, should understand what is the real objective of the statute. What triggered them? They are equally important to understand and apply that law. So OTS scheme reset, old insolvency laws repealed, new insolvency laws were brought in. Expediting the entire process was the key for unlocking the wealth, and therefore they brought in also the concept of the information utility, a completely new idea, so that any financial creditor to whom the corporate entities are, suppose they owe some amount of money, that will be always put up in the public domain of information utilities, so that there will be no question of dispute somebody cannot create. And the design of the law is such that it can be, and that is why throughout the statute the time is seen as the essence. That is the entire design. And the corporate insolvency resolution professionals are another design, where suppose an entity goes into insolvency and it is admitted by the adjudicating authority, NCLT. What happens? Then the management has to be taken over by an independent entity. Under the OTS scheme, there was no opportunity for the creditor to understand the business prospects, financial health, and the internal accounts to be able to enter into a kind of arrangement of a negotiation of an insolvency action. Besides, it was always left to the board or some of the subordinate officers to quantify the OTS proposal. And it was always susceptible to various scrutiny, audit scrutiny. Not, it was also taking time. And to done away with that, an insolvency process was brought in. So it's a fresh law, a new idea, a completely new structure, new management. So under the IBC, when a resolution professional is appointed, he will be the de facto management. The existing management will be sidelined. And within a timeline of 180 days, he will have access to all the business prospects, accounts and all. Then he can prepare an information memorandum and then the resolution plan, which in that event is a win-win for all. The creditor will get to know the financial status and will get to know every status through the insolvency resolution professional. And that is how the state entered into through insolvency resolution professional to understand the financial health. And that was the game changer when it comes to the new regime. But while we are discussing IBC, always keep in mind that the other legislations are still operational, and they are broadly recovery enactments. But IBC is never an enactment of a recovery. It is always an insolvency law and bankruptcy law. And as far as the creditor's liquidation, as far as the creditor's triggered liquidation is concerned, this is the law for liquidation. But for the purpose of a company liquidation for other entities, the Companies Act takes care of it. So therefore, one need to understand how the Companies Act operates for a company regarding its insolvency, how the IBC operates for the creditors triggered insolvency and liquidation processes. Similarly, one should also understand that there are two other laws, Act of 93/2002, how they operate. So now I am ready to take up all those questions regarding the interplay of all these statutes. And please, friends, always remember, we are in really a complex era. Why? Nidhi have read one aspect saying that the judicial jurisprudence needs development. Now the time has come, and it's our responsibility. The institutions are ours. We are the servants to these institutions. We are also serving to the people who are expected to be served through professionals like us. Now, for the students part of this is one of the great opportunity to work. But I tell you, while I speak, citing COVID, yesterday only, the Government of India, the Cabinet, has passed a resolution to suspend the IBC for a year, for a 6 months period. That is the level of reactive and proactive government we have, and which is good. But the point is, we need to keep pace with that. The legislative path that over a period of last 4 years for the IBC that we have traveled, you will be astonished to know about 95 notifications, orders, rules, regulations, amendments under the IBC has happened. Keeping pace. And not only under this, there are different legislations. All legislations are operating simultaneously. Amendments are being carried out. Now, to understand these amendments and interplay between all the statutes, perhaps is a bigger area to operate, either as a professional or, for that matter, as a corporate honchos or a law firm executive. These complex interplay is now on our shoulder. We need to carry how the judicial journey happening through the judgments. It is our responsibility. Getting opportunity, not addressing the problem, then cribbing on this is certainly not an answer. Today, you ask any professionals like me that what is the IBC is all about? Is it really there is some clarity on the ground? None will tell you with absolute clarity. With all my humility and control and command, I say so, that none of us can say with absolute authority that we have complete clarity when it comes to the IBC and the judicial journey that we have traveled. Whether it is judgments like Swiss ribbons is innovative, whether it is on the Supreme Court judgments, NCL and NCLAT, these are issues which we will broadly highlight how we have traveled all through. Mind you, the objects of the reasons of the statute says that it should be done within a time-bound manner to hasten, to improve the wealth, the value of the assets of such persons. Now, there is a sense statutes map through time. Everywhere time is there. But again, through judicial pronouncements, these timelines are treated as not mandatory, but directory. Now, for a layman, reading a statutes, and then for a professional, that's the gap. And when Major General Mr. Sarma told me that the professionals reading the text of the statutes as a theory and applying it in the ground as a practice, there is a gap, and that they need to really enlighten themselves to be able to really come up to the challenges of the future as a professional. I say this, there is much of the effort that contribute to this gap. Why over a period of 4 years of a journey of 2016, a single legislation, we have 95 interventions of the executive and the parliament put together, either in the form of an amendment or, for that matter, in the form of a regulation, circular, orders, reports, rules. And most of these amendments were carried out as a reaction to the judgment standard, because that's where we realized that if an application of a text of law, something is not falling in well, then the legislature and the executive come into picture and corrected it, even through IBBI, the Insolvency Bankruptcy Board of India, which regulates the insolvency professionals and agencies and information utilities. So these are critical time for a students and the professionals, including the academicians, that they must now understand what is the era, how the legislations are being made and how amendments are being carried out. And most of this, and interesting part, most of these amendments to the IBC 2016 was carried out through a ordinance, and that through retrospective effect, though the legislature has that power. But imagine the application on the ground. Imagine the application on the ground. Article 132, 123 for a power of ordinance. Now, yes, the legislature has a power. Now look at this, how I am operating. The Code of 2016, which talks about 11 amendments to repeal. Then there are 2 existing laws of a Banking and Finance Law, Act of 1993, then Act of 2002, SURFACI Act. Then think about that, how there are other legislations are having an interplay, whether it is Limitation Act, whether it is other Companies Act. So all these legislation, even though they occupy the respective field, but today with the proactive and active actions, including these courts intervention, we are operating almost within no time, and that's perhaps is a responsibility that you as a student and as a professional have to carry forward to the next generation. That yes, this era is gone are those days eras where amendments used to happen in after a decade. Look at this legislation of IBC within 4 years. Now it is getting suspended. And look at the IBC operation. IBC, as one of the critical, is a section 4. Read it for sometimes you go and read it. Any amount of default 1 lakh and above can come within the purview of IBC. In other words, an employee getting 1 month's salary of say 1 lakh and is not paid within the 7th of the next month. See the consequences. Within 7th day of the next month, an employee doesn't get the salary. He can trigger the insolvency bankruptcy court. Can you understand that? Do you understand that? What does that translate into? That means the entire ecosystem can come within the IBC qua the companies, qua the individuals, qua the participants. Do we have an ecosystem where we are cash rich? Where do we have a economic environment? We operate with absolute ease. Now, IBC we brought in the May 2016 with the mandate saying that anyone where there is a default of say 1 lakh and above can come to the IBC with the NCLT only. Then at that point in time in Delhi and NCLT about 4 and 5 forums and new forums were created. I mean the existing forums were given that responsibility. Now can you imagine that how many number of cases could have fallen into it? Now only recently, I think this March end, the government realized the problem associated with it. And in fact, let me tell you, today on practical ground, the IBC is not yielding the result. And that is why I'm saying, look at the journey that you will understand that what role you want to play, an active role, constructive role. Criticism is always all right, but the point is, can we really play some active, constructive role, either as an academician, either as a student of a next generation lawyers, or for that matter for a layman? Anybody can come, except the fact that the categories of classes of creditors, operational and financial creditor, there are some classes of creditors may not fall in either of the category, and therefore they will may be outside the purview of the IBC jurisdiction. But the fact that 1 lakh and above threshold for the purpose of the triggering IBC is a massive area to operate at. And that is the reason government realized, and now it has increased the threshold from 1 lakh to 1 crore in March 2019. Look at the proactive government. That's good. Now they realize that we do not have an infrastructure of NCLT, NCLT, for that matter, in Supreme Court to handle thousands of cases. And if you see the text of this IBC, this is my view. It has not come up in the form of a judgment as of yet. But IBC was a exercise of a handshaking in lieu of the OTS. But unfortunately, that is not the case on the ground. That is a subject we will discuss some other time. Yeah. So,
can I just
yeah.
Thus, there are two issues which the attendees are asking. One, they are asking the full form of this OTS scheme.
Okay.
OTS scheme. And second question that is coming up is that it increased from 1 lakh to 1 crore. Is this a short term increase because of the pandemic? Is it going to continue further cost?
All right. Now, number one, as far as the OTS is concerned, this is called the one-time settlement scheme. And this was a scheme propounded by the and this was applicable qua the financial institutions and bankers. This is the structure of the IBC. So suppose earlier, so I hope on that there is no problem and you understood the so OTS. Now, second point, answering your second question, that whether the increase of the threshold from 1 lakh to 1 crore, please understand, currently with the if I'm saying it correctly, 28th of March 2019, this threshold was increased by the government through executive route by notification. Now, whether it is for a temporary period or whether it is for a longer period, I wanted to tell you that the notification that I know is in exercise of this section 4 subsection 2, and currently it will operate at a 1 crore only. Unless the government through another executive notification will change that threshold. And if the threshold has to be increased beyond 1 crore, then it has to go through a legislative change through amendment of section 4. I think I answered that question. All right. Now, so from the standpoint of the individuals, participants, corporate individuals, corporate entities, all are covered under the IBC, number one. And the fact that everybody can be prosecuted under this. And once an application is filed either by the financial creditor or by the operational creditor, it has to be admitted within 14 days. Though the timeline is treated as a not mandatory but directory, but be that as it may be, when an application is filed for an enforcement of such dues, then it will get admitted and then the management will be ousted and the new management in the form of a resolution professional will take over. Then they will undertake the day-to-day functions of the operations of the corporate data. Now here, please note, in a way, if you see it on the way the IBC has been applied till date, it is a death knell for the promoters and the investors and management alike. Whether you are a good promoter or a bad promoter, notwithstanding. So therefore, IBC has a direct impact throughout the sector, 1 lakh and above, till the 28th March 2019. Now post that, now 1 crore and above, number one. Number two, the nature of the dispute that could have been, the jurisdiction of the IBC is where there is a debt and there is a default. And this is not disputed. So these are the three important aspects you should remember. So any amount, either from the financial creditor side, dues from the financial creditors, or dues to the operational creditor, they are vendors, they are salaried employees, statutory dues, everything. If you fall in the category of the operational creditor, you can prosecute against them. So it works both ways. So therefore, a company who can invoke the IBC as an operational creditor against another company also is not set for his dues to another company under the same section. So it operates both ways, right? Now, Am I audible? Am I audible? Am I audible? Am I audible? Hello?
Yes, yes, you are audible.
Nidhi, am I audible? Am I audible?
Yes, yeah, Mr. Das, you are audible.
So, I always have stated that for professionals, IBC is a massive area. Because of the complex regulatory provisions under Companies Act, IBC, and many other corporate laws, the company secretaries and chartered accountants are also given the entitled to practice before the adjudicating authority. And you as a professionals also can participate and can join the insolvency professionals. And that is also another area of practice. But for the purpose of the management and for the purpose of individuals, this is a risk factor which I have told you. So broadly, I have covered this in terms of the design of the law, the complexities. Now let us now understand the judicial development over a period of time. Now, as I have told you, this government is this parliament is very reactive and proactive, and most of these amendments were carried out through the court procedure or judgments to address the court's judgments. The intentions of the government is very clear, that we wanted to remove the bad manager, the bad promoter, bring in the fresh blood, fresh idea, fresh energy, unlock the wealth. That's a very good idea. But they're running into the rule of law. They're running into the judicial principle. For example, if IBC, a petition is filed, either under section 7, 9, or 10, now that has to be admitted within 14 days. Now, if the concept of the odi parte alterum, if it has to be exercised, then how do you deal with that? Now, the way I am looking at the IBC, for you to really ponder upon it, and perhaps we'll exercise that way to understand that whether the original structure of the statute was like this or not. The text of the statute as it stands, if somebody is coming at that claiming that I'm an insolvent, that the corporate debtor claims that I'm an insolvent, then embrace it and apply the OTS principles and then allow them to operate. That's one. Number two, if it is not a case that where insolvency can be addressed, then obviously the company will go into liquidation. Same way, if the creditors, whether operational creditor, whether the financial creditor, any money is due to them, if they come seeking resolution of an insolvency, not as a part of a recovery proceeding, then also the consent of the corporate debtor must be brought in so that they will not dispute. And then the 14 days of admission of the insolvency proceeding could be achieved. But we went into a different tangent. That is what is my reading, and that is the area for a research for the universities like MIT to understand where IBC is digressing, why we needed so much of amendments, why the application and the texts are actually on the two different tracks, why we do not have a clarity with all institutions with a good intentions, we are unable to come forward. These are a subject for a research, for a professionals, for a management, for a universities, for our students next generation, and I always request my colleagues, next generation colleagues, IBC is, believe me, is a great law, but as my hunch says, IBC is certainly not going to run for a long time with this digression, and perhaps the first indication is yesterday when the cabinet, though cited COVID, but has brought in a change saying that we spend it. A. B. The threshold increase from 1 lakh to the 1 crore again is an indication or a endorsement of my predictions earlier. Now let's come to the main area where I told you that all the amendments were carried out through the judicial, whether it is Mobilux, whether innovative, whether it is n number of Supreme Court and NCLT and NCLT judgments. And we can discuss on case-to-case basis. That will be more interactive. That will be very good. The other law. Third is
Mr. Das, due to
and with
your
respect to
audio
the
and video
and default. Any amount of debt, if there is a default, an insolvency can be claimed or can be triggered for the purpose of a resolution. Unlocking the wealth, correct? That is the IBC. Where it comes to the Insolvency Act, it only covers the enforcement, recovery enforcement for the secured properties. We all bankers and financial institutions, suppose if I take a loan of say 10 crore and I give it a mortgage, that is called either in the form of a bank guarantee, a lot of, there are secured collateral security, that's called the secured creditors. So to the extent of the secured amount and secured creditor, that was enforceable through a recovery procedure called the Insolvency 2002. Now, for unsecured amount and for also the secured amount, another law of 1993 is available. So, broadly speaking, every legislation has its own space with its own objects and reasons. Now, and all of these statutes have a coexistence. But from the standpoint of an individual entity, individual grievances, for example, an investor, he may have against non-recovery of money. A creditor may have a non-recovery of money. A corporate entity also may have a grievances for not being able to repay. There may be some genuine reasons. So, all these legislations have their own interplay. Now we have to work out a solution and the clarity will be there on the ground. And that is why you and me have a responsibility and the opportunities are plenty. And let me tell you, the IBC also covers the offenses and penalties. A lot of existing general law like IPC and all, they are all being taken. And our IPC, for example, is getting redundant for the civil remedy or a civil offense, or for that societal civil offense, that is 420. A lot of offenses, fraud, cheating and all, they are being now captured through different special statutes. So the opportunity for a next generation is to understand the new generation of law, and IBC gives you ample opportunity. And with the kind of a complexity it throws at us, if we really can solve this problem of unraveling this complex interplay, you will be the winner. So broadly, this is my argument. I want now some kind of an interactive exercise where I will be able to answer those queries, whatever form they may come. If a general, Major General Mr. Sarmaji, if we can put up some questions, or there are other questions which has come from the participants.
Yeah, Mr. Das, there is he says that a company coming under IBC has not performed over many years. How can anyone expect to perform and pay the debts to his creditors within a stipulated time frame as mentioned in the IBC code? Is it some way a disruptive and not giving enough opportunity to the company to show its growth?
I'll tell you. I declare IBC is not a recovery. IBC is not a recovery law. Courts have always spelled out. But on the ground, IBC is implemented as a recovery law procedure. That's the dichotomy that we are passing through. And answering that question, IBC is actually a resolution procedure and a resolution proceeding. It's like a handshaking between, yeah, baby, Raji to kya karega Kaji. That means the corporate debtor and the creditor must come forward saying that, okay, listen, let us go for a one-time settlement of a resolution of my insolvency. And therefore, I am giving you the option to enter into my management and understand my financial health, which earlier that kind of a regime was not available under the OTA scheme. Look at this. Suppose if both parties agree, then the 14 days timeline is achievable. Yes, I owe some amount of money. Please understand, we are not operating in a very, very ideal environment. We are not operating in a very ideal environment. If a company is not able to pay to a company its debt, it is also not being able to recover from a company called B. It's all chain reaction. There may be instances of bad, malicious intention that I am a cash-rich company, but I'm not paying it. But for that also there are adequate laws available. And yes, here is a law which is, and that is why I'm saying why the IBC is getting digressed. And it is not a disruptive law. The way we are applying it, I say with all humility, with all sincerity, the text of the law that I have understood, the text of the law that I read and you read the text of the IBC the way I have read it. Some other time we will discuss that how we will read it this way. You will see that IBC is one of the finest possible law. But over a period of time, it has been seen as a disruptive law. And look at this. If you realize that the IBC is not achieving its result, and I see the reason for not achieving its result or people claiming it as a disruptive or a draconian law is the way they read it, or the way they read the application of the law. Any other question? Nidhi?
Yeah, IBC where companies connected are in distress.
Well, this is the two executives, they are trying to address one time resolution plan for a group companies. But I tell you, there is a problem, larger problem in this. Now, whether there are larger problem. The current existing design of the law is will not be able to address this issue because there are different actors, different players, and that is why when we are trying to address these issues, one-stop solution, when we are saying one size fits all approach, that is where all the problem lies. And according to me, this approach is certainly will not be a very welcoming exercise, though there are other thought process now operating at the government level to work. But I think separate expectations. Now, when it comes to recover every entity in a group company, there will be issues of their respective compulsions. Now, how do you address through a legislative design one-stop solution for all? Yes, but if we use it as a concept of OTS, it is possible. But if we use it as a concept of a recovery, as it is getting applied now on the ground, then there will be a problem. Now, what kind of a legislative design we can bring into it? And today, let me tell you, the application of the IBC, according to me, and I can show you A, B, C, D, has breached many established rules of construction, many established rules of jurisprudence. And that's why I'm saying the new age designed law needs a new age designed jurisprudence to address it. Otherwise, we will apply it wrongly and we will creep for it. We will try to address the problem which is on a wrong track, hoping that this is the right track, and then we will amend that law. What will happen? When you are standing on a wrong track, trying to correct, claiming that it is the right track, then the solution that you will offer will always hunt you down in days to come. And that is precisely the IBC's fate now.
Okay. Another question, is it possible to proceed under IBC in those cases that would otherwise fall under the SARFAESI Act?
Sorry, come again. Sorry, come again. Sorry, come again. I didn't hear you.
Is it possible? Can you hear me now? Can you hear me now?
Yeah. Yes.
Okay.
Yeah, I can hear you.
Is it possible to proceed under IBC? Is it possible to proceed under IBC in those cases?
Okay. The question is it possible to proceed under IBC that was within the perimeter of SARFAESI Act? Is it so? Is it the question? Yeah. Is it this question that whether it is possible to pursue under the IBC, which is otherwise falling under the category? Okay. I told you.
Also for the SARFAESI.
SARFAESI.
Yes.
I tell you, SARFAESI is a different field, and IBC covers how SARFAESI enforcement of a secured property, and IBC covers secured, unsecured, anything under the category of the financial creditor and operational creditor for the purpose of insolvency resolution. So, while a subject can squarely fall within the perimeter of SARFAESI, a choice is there with person concerned, the creditor, instead of invoking the SARFAESI Act, can always trigger the Insolvency and Bankruptcy Code. And that is the beauty, that if we can work out in a manner where the text suggests one thing, then there will be no confusion whatsoever on the ground. I think I answered this question.
I have a very basic question. Maybe it may sound very, very basic, but in the definition of claim, or the
Okay.
will
Okay.
because claim.
Okay. Now, please understand what is claim defined under Section 3(6). It means right to payment is one category, and second is right to remedy for breach of contract, which when gives rise to right to payment. Okay. And the word claim is actually, you will find it also there in Section 521, qua the operational debt. Okay. So the claim has a definition, and it says right to payment or right to recovery, right to remedy. Now, when you talk about the breach of contract, obviously the contract law will come into play. Now, for example, as far as IBC is concerned, to trigger the IBC, to initiate the IBC, the basic test is the default. What is default? Default says there is a non-payment of debt when it is due and able but not repaid. Now, what is debt? That is non-payment of debt. What is debt? Debt means liability or obligation in respect of a claim. So, what is claim? Claim is the right to remedy where there is a breach of contract. So therefore, the contract law will come because when the parties will go for an insolvency resolution, the test is if a company owes some money to a creditor, and that amount of money is not disputed, and that amount of money is due and payable, demanded but not paid, that is when it will come into picture. So obviously the contractor will come into play. That whether I owe the amount of money or not, and it has to be, please note, decided and all, it has to have no dispute whatsoever. So that means it has to be borne out from the contract. It has to be borne out from the court. An undisputed contract, undisputed dues, payability. That's the test. So claim has a link with the contract law and contract law, and all kinds of law will have its application, except that if there is a repugnancy between the equivalence of some other law, the IBC will prevail. So why should even the contract act will be a repugnancy? So there's no problem. There's no problem. And it's interesting. When the virus of yeah, any other question?
Okay. Dinky School is asking the question, what
Mediation.
Yeah, yes.
I'll tell you, let us understand, IBC itself is I believe that it is more of a conciliatory exercise, where both parties agreeing, and mediation doesn't have any role in the IBC. Because please understand, mediation is a layer of process prior to adjudication of rights and liabilities. It's like a plea bargain. Like, for example, before I punish you more, are you ready and willing to enter into mediation? So IBC, the mediation concept for IBC is certainly not a very good idea, and is certainly, according to me, is not syncing well with the design and the concepts of law that we understand as far as the IBC is concerned. And I'll tell you why somebody will enter into a mediation. Mediation, the creditor will not get to do all the finance.
Okay. Okay. Some more questions. I'm looking at the chat. And from there I ask questions, put questions by Mr. Das. If some more in the question answer, or if you see the question answers there.
Sorry? Hello? These are so small. Unfortunately, I'm not able to.
I know.
Yeah.
Maybe can you see that?
To really read them, can you just can you help me?
Because I can see.
Yeah.
just for a minute, just for the question. Jyoti, are you?
The chart sheet, there is a Q and A sheet is there. Please click on the arrow of the Q and A.
Where? Below?
Just below the chart sheet.
No, no. Where below? Just
Yes,
below
sir.
that. Because I have the questions that I am seeing are on the.
So just minimize the chat sheet and click on Q and A, and it will open.
I can't see below the chat. I can't see question answers.
But I just want a little bigger in size so that I'll be able to read them here.
Sir, please drag it up, sir. Drag it up.
Dragging where?
So just between the chat and QA, if you go over the mouse there, then double arrow is present to show you.
Hold on. Okay. Will it be?
I
Yeah, please. Understand. Then what you have to understand the consequences of insolvency. Like, suppose if you are not able to pay, legislature give you this law saying that, okay, you can claim insolvency. Now, suppose there is a tax due available. Now, you are unable to pay that. Correct? Now, what will happen? Now, I certainly can go for a insolvency proceeding. Then in that event, depending upon my financial status and health and all, the insolvency will be an individual, obviously, taking the IBC Code 2016, and it has not been taken off that. It has not been taken up, and it has to be taken up before the DRT. So, and this is still evolving. Now, yes, he can claim, number one, answer. But then you already need to understand that what are the consequences of claiming insolvency, right? There are some impacts. There are certain obligations. Now, you have to deal with those obligations. But yes, you can insolvency proceeding, trigger that, initiate that proceeding, even against the statutory dues also. Because that's exactly the legislature wants to unpack that amount, and if somebody is genuinely insolvent, the adjudicating authority will decide that.
Okay, one more question. In present era,
I'll tell you, today the problem of the law, today the problem is the ecosystem. Today's economic problem is more of a regulatory. I always say that economic scenario in India is facing one of the biggest regulatory risks. And I mince my no word into it, and let me elaborate it. There are sectors. You identify the sectors. For example, mining sector. For example, power sector. For example, food sector, processing sector. You identify the sector. At least I can tell you with absolute authority, as I am so closely associated with the mining and power sector. And mining, majority stakeholder in the entire spectrum of the economy of India, correct? Because this is a basic engine for a growth of economy. And out of 13 lakh, as I speak, out of about 14 lakh crore NPA, mining sector is exposed to about 8 to 9 lakh crore. You know why? It is not because of the regulatory risk. It is not because there is a siphoning of fund. Siphoning fund is always a part of a law of averages in any sector, and even the bankers and financial institutions know that 10% roughly will be siphoned off. But at least 90% of the wealth is still operating in the sector. Then why we are getting this amount of NPS? Because the plants, infrastructure is all ready, but idle. Because regulatory clearances are not. Running university, educational university. At any given point in time, if you will have to be administering about 25, 30 laws, sometimes crisscrossing with each other, how do you operate? Today, most of your time, and let me tell you, I am talking about the government. Governments, most of the bureaucrats, most of the time, 80 to 95%, I am actually quoting the bureaucrats. They are saying 90% of their time, administrative time, is going in court cases, handling litigation, or in one way or the other. So if, and yes, as a lawyer, I have nothing to complain. And for our students of a law, they may see the opportunity, but sometimes I introspect. Can I not use my opportunities in a responsible manner for a constructive economic augmentation and a growth? And should I not talk straight? And economy, see, nothing comes for a free. Every action has equal opposite action. If I work in a negative way, somewhere down the line, even if I am getting benefited right now, but it will come and hunt me down. And today, look at this economy status. So even in the IBC, as the statistics say, they have been able to unlock 3.5 lakh crores, for example. But apply on reality. Those 3.5 lakh crore unlocking only happens on the pen and paper. But those businesses are grappling with those regulatory risks even till today. And even if they are, promoters' hands are changed. One promoter is removed, another promoter is brought in the insolvency proceeding. But the same business risk and environment is hunting, is staring at them. So as a lawyer, should I see only the law part of it? Should I not see the reasons? That's why I say, and I suggest Major General Mr. Sharma, please try to find out the factors which contribute to the divergence between the text of the law and the application of the law. And why we always tell our students that theory and practical are different. Believe me, theory and practical should not be different. The only thing is that if we can identify those factors contributing to this divergence or difference, we may perhaps will be able to answer those factors and get ready ourselves to a next generation. And therefore, all the lawyers who are operating in this regulatory risk environment have a role, not only for their own benefit, for the overall benefit of the economy and the sector. They must look forward the aspects of, and another important aspect, the IBC, why I always call it as a conciliatory exercise. If you read the objects and statement, it says that IBC separates the commercial aspects of insolvency proceeding from the judicial aspects. Therefore, at the insolvency proceeding level, we only talk about the conciliatory exercise, conciliations, and more of a resolution and a commercial consideration. And commercial considerations cannot be the domain of the adjudicating process. Anything else? Yeah.
Okay, one more question. India ranks below 100 when it comes to resolving insolvency. So what according to you are the shortcomings?
लेकिन जब मैं बोलती हूँ तो आती नहीं क्या?
Okay. Okay. What are the shortcomings of IBC? Okay. Number one, IBC is, please understand, IBC says that we need to unlock the wealth in a time-bound manner, correct? Therefore, throughout the statutes, we have identified 14 days, 10 days, 7 days, 180 days, 330 days, 270 days, correct?
Yes.
Now, through judicial interpretations, we have termed them as directory, not mandatory. What does it mean? What does it mean? It means that the IBC is not to be enforced in that manner. And why even we had to go to that extent saying it is a directory mandatory? We went into the exercise of directory and mandatory, treating the IBC proceeding as a judicial proceeding. Now, the day we will say that the judicial proceeding is a test of rule of law and it has to be implemented and giving opportunity to other parties, then that means we are actually taking the IBC proceeding as a the disputary exercise, and that is not the intention of that IBC. So one of the reason is the text of the law and the application divergence of that. That's one of the reasons. A. B. There are also the players like us have a role, and we have to read it the way it should be and find a way, even through institutions, to apply it little differently to be able to achieve its objective. Otherwise, can we say that we will have to implement it, we have to finish the IBC proceeding in 180 days? Imagine a situation like SR Steel. About 54,000 crore worth of the total cumulative creditors. And the insolvency professionals, resolution professionals will have to collect all these data and all. Can you then expect them to finish it within 180 days? Then is there not a issue of a dispute? Who is entitled? How much is entitled? How much money is to be paid and all? So please, the design was for a period. That period is only be possible when we apply the IBC in the context of the existing designs like the OTS, Act of 2002, Act of 1993, interplay with everything, and then say that other party like corporate debtor. Suppose if I have a money, I claim say 100 crore against a corporate debtor. Example. Now I tell him that, look here, you owe me 100 crore. He says that, sorry, I'm offering you 60 crore. I said that no, nothing doing. Let's go for an insolvency proceeding. Now, so that I'll be able to do financial help. Now he agrees to it. Suppose he doesn't agree, then the consequences under 65, 67 is there. Suppose a corporate debtor maliciously and fraudulently denies the insolvency proceeding, yet doesn't pay me, there are also consequences. So apply the law in a holistic manner. We know the construction of the statute. We know the interpretation of statute. The statute needs to be read in a whole, but we are not doing it. So these are the parameters we have to understand. Otherwise, how do you expect the IBC proceeding will be taken to the level of a adjudicatory process, and you do not wish to give the opportunity to the other party who may have a genuine grievances against the insolvency proceeding? Do you then expect it to be finishing in 180 days? So IBC needs to be applied the way it is meant to be, the way it is designed, not the way that we want to read it according to our own whims and fancies.
So,
okay, I think I'll take the last question. We have Sanjum Bedi, one of our faculty. She's asking, can I own any after I am declared bankrupt? Could you hear me? Could you hear me, Mr. Das? Can I own anything after I am declared bankrupt?
Okay. See, that's what I said. When you asked me another question regarding the bankruptcy proceeding, qua the statutory dues, insolvency proceeding, qua income tax and all, this is linked to that. See, if you are declared as a bankrupt or adjudicated as an insolvent, there are prices attached to it. like you cannot own property. Obviously, if you own the property, then that extent of ownership of the property will be subject to a recovery for those affected parties owing to your declaration as a bankrupt. They will have a first lien over that property that you acquire. For the time being, you are declared as a bankrupt. That does not absolve you from your liability forever. As long as you continue to own post that declaration of a bankruptcy or declared insolvent, that ownership will be subject to subject to claim of those affected parties in a proceeding of insolvency and bankruptcy proceeding. Right?
Sir, last question. I just want to know, we have EB there, and it basically regulates the whole this insolvency thing. We have this participant agency, we have participants. So when we talk about this insolvency participant agency, why BCI, Bar Council of India is not there? Why advocates are not the member under this participants? They can't be considered as insolvency participants. Why only your cost accounting people are there, your CAs and your CAs are there, though this is a quasi-judicial body and the whole proceeding is quasi-judicial. So why lawyers are exactly not the part of this insolvency thing?
Okay.
Exactly not the part of insolvency.
I tell you. You are asking me a question concerning the resolution professionals, then resolution agencies, and you are also talking about the practitioners who practice before the NCLT and NCLT, correct?
Correct.
As far as the handling cases on behalf of the corporate debtor, or for that matter, for the corporate financial creditor or operational creditor, the people who can participate before the adjudicating authorities like NCLT and NCLT are obviously allowed with the advocates. Other categories are allowed through a statutory enactment, that is the chartered accountants, company secretaries, and the cost and management accounting CMA. They are the practice. They are the professionals under different statutes. They have a different skill set. They are recognized under this IBC, including under the Companies Act, that they can participate before the NCLT as a representative before the petitioner and respondent. Petitioners are maybe the corporate debtor, financial creditor, operational creditor, or the respondent side, correct? So that is a practicing. Now, as far as the lawyers are concerned, the regulatory body is the Bar Council of India. And as far as the other category of the professors permissible under the IBC to practice before the adjudicating authority, they are guided by their regulators like the ICSI, ICAI, and ICMAI. That is the practitioner's representative capacity. Now let's come to the insolvency resolution professionals, IRP, and then insolvency resolution professional agencies. Under the Part 4 of our IBC code, the regulators of those category of classes of professionals, including information utility, is a new design under the IBC. They are guided additionally. They are guided by the IBBI, Insolvency Bankruptcy Board of India. They are the regulator. As far as the IRPs are concerned, those are the people who will govern at the interim stage during the insolvency. They will conduct the insolvency resolution process. And they have been mandated under the statute that these are and in that, all can give example. There are eligible criteria, including lawyers have become the insolvency resolution professionals. So suppose if I'm a lawyer, suppose your new 5-year law program students, when they qualify themselves, they will become eligible to become the advocates. Now they will be eligible to be governed by and regulated by the Bar Council. But for the purpose of discharging the role of a IRP, they are participants under the agencies. They will have to qualify under an exam, criteria matching, and then regulated by IBBI. So, a IRP a lawyer becoming an IRP will be guided under two categories and under two separate statutes. One under the IBC through IBBI for the purpose of conducting the IRP, CIRP, and another for the purpose of representative. They will be guided by two regulators. One is the Bar Council and then IBBI. Is that clear?
Yeah, sure. Yes, absolutely correct, sir.
Is there any
format?
IP?
Hello? Hello? Sorry? Yeah, I can hear you.
Can you hear?
Yes.
Can you hear me, Mr. Das? Is there
Yeah.
any specific
Network is poor.
format of
Network is
filing going to the IP?
sorry.
Consulting. NCLT.
Yeah, I can hear you now.
Yeah.
Yeah.
Can you hear?
Yeah.
Mr. Das, can you hear me now?
Yeah, I can hear you.
Insolvency के लिए बाकी तो NCLT है.
I can hear you. I can hear you now. But it is disturbed.
Okay. I'm sorry, every time we say last question, but definitely
I'm not able to hear. I'm not able to hear. There are disturbances happening actually. There are disturbances. Any question?
now. Can you hear me now?
Yeah, now I'm hearing. Yeah.
Can you hear me now?
Please. Yes, please. Hello.
Yeah, Mr. Das, he's asking, is there a
Is the question is that is there any
Hello.
specific format for the purpose of appearing in the exam?
Yes.
Okay. So for this is a
It's for the going to the interim professional.
yeah. Okay. Okay. Yeah. The question is there any specific format to appear in the exam for a resolution professional or a specific format for an interim resolution professionals?
Interim resolution. Interim resolution.
Okay, interim
Not-
resolution. You see,
The exam.
okay,
Wait, if I
specific format for interim resolution professionals before which forum?
yes.
Yeah, I'll tell you. The interim resolution.
Just
I
I
have-
will see the
Yeah. The
yeah.
interim resolution professional is actually a subject for the purpose of giving the management of the affairs of the company from the date of admission of the resolution process till the time the committee of creditors appoint a resolution professional. There is a time lag between the admission of the resolution process by the adjudicating authority and the time of appointment by regular resolution professional. There is a time lag. And that time lag, within that also the management of the affairs of company is done, and that is called the interim resolution professionals. And these interim resolution professionals are to be given in the form of affidavit and also the credentials along with the application for resolution process. So the person whose name will be lent at the time of filing of the process for both the financial creditor as well as for the operational creditor. Though the operational creditor, it is not a mandatory, but for the purpose of the financial creditor, it has a mandatory. That insolvency, interim resolution professional name should have to be given. And the format, yeah, there is a format for, and that is actually along with the application, the section 7 and 9.
Okay, I think Nidhi.
Yes, sir. So you rightly said.
Yes.
Yes. Yes.
I think, we can come to
This is the time for
close
vote of
the
thanks. Certainly.
proceedings.
This is time for vote of thanks, sir. Thank you. Thanks a lot, sir. And I'm extremely thankful to my director as well. He has actually suggested me the right person to conduct this session. So you rightly said that the complete accuracy of understanding of IBC is just next to impossibility. And as you correctly noted that there is a divergence between the practice and the theory. I understood. We need to employ your scientific rigor to actually answer this question. Like, then there will be no difference between theory and practice. We have to employ experience, expertise, case studies to IBC study, and then only we will be possible to actually understand what IBC actually want to do. It's not a like a draconic law. We can't state it as. It's a wonderful law. It's something which will be opening for new entrepreneurs. And now I like to ask my director to cast a vote of thanks to you.
Thank you, sir. Thank you.
Thank you.
Yeah, thank this subject, your expertise is fabulous. In fact, it has very, very good opportunity. I saw good about 144 participants at one point of time. So it speaks volumes about your knowledge, and extremely grateful, Nidhi, and to my IT department, Jyoti, who organized this, who worked very hard to do this, well knowing the quality, but still, I'm sure the participants have benefited with your class. We
Thank you so much.
will get more opportunities of interacting with you. Once the situation improves with social distancing, we will also request you to once again come to the university and interact with us. On behalf of entire school and MIT University, from the organizing team, thank you very much, and to Anamika also, your assistance, who helped us utilize. Thank you, Anamika.
Thank you so much.
Thanks a lot.
Thank you so much. My sincere gratitude for your this gesture. Thank you. Thank you. Thank you. Thank you. Thank you.
Grateful. Thanks a lot.
Thank you, sir. Thank you.